Ready? 3, 2, 1, start. In the appeal filed by the defendants against the decree of the trial court, the lower appellate court did not frame any points for determination but observed that the issue number 2 bracket start framed by the trial court bracket close was of paramount importance, which was whether the deceased Balram Singh was a person of unsound mind. Stop. The statement made by the plaintiff respondent number 1 bearing paper number 43A purportedly made under the provisions of Under Order 10 Rule 1 of Code of Civil Procedure was considered and held that this would not be a statement under the provisions of Order 10 Rule 1 CPC. Stop. The court referred to the provisions of sections 1380 and 114 of the Evidence Act and held that no presumption can be drawn that the executor of documents was of normal mind or a brainless idiot at the time of execution of the documents. Stop. The court observed that the consolidation officer had held the plaintiff respondent number 1 as an idiot, which order was never challenged before any court, and held that the decision of the consolidation officer would operate as res judicata in the present case. Stop. It held that admittedly at the time of execution of the sale deed, the plaintiff respondent number 1 was not a person of sound mind and thus he had no right to execute the agreement, and as such the sale deed dated 23/9/1994 executed by him is a fabricated and a void document. Stop. Para. The learned counsel for the appellants has contended that the decision of the Consolidation Authority dated 21/10/1981 in case number 4147 under section 9A within bracket 2 of the UPCH Act cannot operate as res judicata in so far as it declared the plaintiff respondent number 1 Balram Singh as a person of unsound mind. Stop. The learned counsel has referred to the provisions of Rule 14 of the UP Consolidation of Holdings Rules 1954 to contend that the consolidation officer had no power to declare the plaintiff respondent number 1 as a lunatic and that order of the consolidation officer is a nullity. Stop. It is further contended that since that order dated 21/10/1981 passed by the consolidation officer declaring the plaintiff respondent number 1 Balram Singh as a person of unsound mind is without jurisdiction and is a nullity, it cannot operate as res judicata. Stop. It is contended that the consolidation officer, while deciding objections under section 9A within bracket 2 of the UPCH Act, is not a court as defined under the CPC. Stop. While referring to the explanation 8 of section 11 CPC, the learned counsel has contended that the consolidation officer is not competent to decide on the issue of unsoundness of mind of the plaintiff respondent number 1. Stop. It was incumbent on the courts below to appoint the plaintiff respondent number 2 as the guardian of the plaintiff respondent number 1 in view of the provisions of the Hindu Minority and Guardianship Act 1965 and the provisions of Order 32 Rule 3 read with Rule 15 of CPC. Stop. It is contended with reference to the provisions of Hindu Guardianship Act and the provisions of the Guardians and Wards Act 1890. Stop. Over.